Hi, my name is Marie Mainard O'Connell, and I am a transitional associate pastor in the Presbyterian of Arkansas. This video today is for my friends and colleagues in ministry who may be wondering to themselves, wait, wasn't there a law about concealed carry in churches that should be coming into effect soon? Yes, my friends, there is. In fact, there are two. Thanks to the Arkansas State Legislature, as of September 1st, 2017, enhanced concealed carry permit holders will be able to enter your houses of worship without identifying themselves. We're here today to discuss these two new laws that will affect every church in Arkansas, beginning with Act 562. An act concerning the possession of a concealed handgun in a public university, public college, or community college building, concerning other privileges associated with an enhanced license to carry a concealed handgun. Yes, it is the other privileges that concern us today. Essentially, this bill sets out to do something very simple. Expand the rights of concealed carry permit holders who have undergone specialized training to enter more public areas with their handguns carefully veiled from view. The law requires that this additional active shooter training be designed by the state police and take up to 8 additional hours of training. They could spend an entire Saturday on this. I can't imagine a scenario in which this goes poorly. So, what can churches and houses of worship do in response to this new law? Well, you have 3 options. Option 1, keep calm and carry on. Your first choice is to allow the law to work as it was designed to. That is, you can do nothing at all. Concealed carry permit holders must first obtain their enhanced carry license and then attend worship as normal, unobtrusively passing the peace while packing a piece. Ideally, you would never know who is a concealed carry permit holder because they so elegantly obscure their firearm, so that you cannot tell by their words, actions, or behavior that they are any different from a non-armed citizen. In all honesty, there are 220,000 Arkansans who already have their concealed carry permit. That is 7.3% of the Arkansas population. It's likely that you already know someone who has their concealed carry permit, and also likely that they are already in your pews. With this option, option 1, you will likely offend the least number of armed individuals. However, you should weigh it against your culture and context. What do your core religious values say about peacemaking, weapons, self-defense, and human nature? Could you simply ask your current concealed carry permit holders to obtain the enhanced license before they pack the pews?
What about liability?
While the chances are good that houses of worship will see increased insurance rates as a result of increased risk, the law anticipates this and includes a clause that protects houses of worship from monetary liability. It reads, "The person or entity exercising control over the physical location of a place that does not use its authority to prohibit a person from possessing a concealed handgun is immune from a claim for monetary damages related to the decision not to place at each entrance a written notice." So, a church that does not have a policy against concealed carry and thus has no signage is also not liable for any monetary damages that arise from that decision. What is the full extent of that immunity? Well, I'm not a lawyer.
What about the children?
Well, things get really murky if your house of worship also has a school or daycare on the premises, as schools sometimes feel that they cannot permit weapons on the premises for child safety reasons. If this is your situation, you'll need to consider whether your presence of a school on your property requires you to choose option 2 or option 3. Option 2, signs of the times. So, you've had a meaningful theological discussion with your vestry, session, board of elders, deacons, the bishop, your biggest giver, the loudest member, and you've decided that you have to have a policy banning firearms or concealed carry on your grounds. Good for you. Now you're going to need to put up a whole lot of signs to that effect. Good news! The law does not dictate the size or materials for your signs, which means you're completely free to laminate a few sheets of construction paper or get a professional sign in matching fonts to go with your beautiful historic exterior. Bad news, You will need to post signs at each entrance to your building, and in a few locations that are confusingly worded, such as near the roadway entrance. Also, your letters will need to be big enough to be read from 10 feet away and include the words, "Carrying a handgun is prohibited." This modern eye chart suggests that your letters need to be at least 1 inch tall, and probably not in a thin, unrespectable font like Comic Sans, but bold, like this "For Sale" sign.
So what about liability?
Good question. Some of you are probably wondering whether by choosing to exercise your authority to prohibit concealed carry and to post signage, whether you are now liable for monetary damages arising from that decision. At this point, you probably need to get a lawyer. The one I consulted said that you probably are not liable, because the law usually does not confer liability by negative implication. It is hard to imagine a court imposing liability in this situation. However, the law is admittedly unclear and probably needs to be litigated in order to find out. Did I already say get a lawyer? I meant to say that. Compromise option 3, if you see something, say something. Lawmakers realized that requiring signage might be a burden on churches, and so Act 859 gives us an interesting third option. You can have a policy prohibiting concealed carry and post no signage on it, provided that at each violation of your policy, you notify the offender in writing or verbally. I don't know who gets to have that chat.
Wait, what about liability in this case?
Well, at the first violation of the see something, say something option, the offender is not in violation of the law unless they remain or return to your house of worship while still armed. The law isn't actually clear as to whether the institution is liable for not posting signage when there is a policy, but the verbal or written warning is intended to cover this situation. Really, I can see where this option might be the best solution for many a religious institution, but I think you need to have a serious conversation to be certain. So, there you have it. Your 3 responses to Act 562 and 859. You can keep calm and carry on. You can post signs of the times, or you can see something, say something. If you don't like any of these options, you can contact Reverend Steve Copley as the chair of Faith Voices Arkansas, faithvoicesar@gmail.com, or 501-626-9220 to share your concerns about potential violations of the separation of church and state, or violations to your First Amendment right to the free expression of religion, or for the need for legal clarity in this law as it regards liability. Legal suits regarding the constitutionality of this law may be required to change it at this point. Is your community called to take such action for such a time as this? And of course, I hope that your response to all of this information is first to pray for direction and discernment, for clarity and peace. This is Reverend Marie Mainard O'Connell in the Presbytery of Arkansas. May God bless your ministries. Good luck. Amen.